Hi everybody, I'm JD Hoovener, your host of the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily inspiration so you can make the world a better place. Today we're talking about design patent infringement. And we've been talking now in this 10-part litigation series about all of the steps and requirements that are part of the case. And just yesterday we talked about utility patents and the need for what's called Markman hearings. And that's part of the development that a judge goes through in their decision on what terms within the claims mean. And it's called claim construction, is this process. Today we're going to focus on designs. And as you may know, right, designs are a very different type of enforcement vehicle and a different statute altogether. Under 35 U.S.C. section 171, the Patent Office will grant ornamental designs that cover what's called an article of manufacture. And so something that may be produced, right, brought about in the physical world can be protected just by the shape of it. Okay, not at all to do with what it does functionally. That's the domain of utility patents. Design patents cover what something looks like. And so the infringement process, right, is different too. So I want to point out some of the key differences today on what design patents and the way they're litigated in today's federal circuit. What you'll notice if you ever pull up a design patent is that the lines that make up a design are either solid or dashed. And we've gone over this before in previous Bold Today sessions, but if any of you missed it, the key point about the difference between those two types of lines is that the solid lines are what's claimed. That's similar to the utility claims that are written in the claims, right? The words that are written down at the very bottom, numbers 1 through 20 usually. Not necessarily all the words that are in the specification. Similarly, in a design patent, those elements that are drawn in solid line are being claimed, whereas all the elements that are either hashed or dashed line are not being claimed. So those are much akin to this specification in the utility patent. So when a judge gets prepared to construe the claims, they're really just confirming, as a matter of law, what it is that's being claimed, what physical three-dimensional shapes are being claimed for this article of manufacture in this design patent. The standard of proof is also different. That's the second biggest thing we're going to talk about today, is that it's not this preponderance of evidence as utility patents are. It's actually what the jury looks at is they try to put themselves in the ordinary observer category. So someone that's going to purchase, let's say, a pair of new Nike shoes, someone looking to purchase shoes, would that person in a position that's as a customer be with the accused device, right? Let's say someone was ripping off the Air Jordans. Would someone think that it's substantially the same design? So it doesn't have to be exactly the same, but that's the test. An ordinary person put in the same position as if they were a customer, would they think that it's substantially the same design? That's the construction, sort of a reasonableness standard, as opposed to a preponderance or even a above and beyond that. So I hope that gives you some insight as to what design patent litigation is all about. If you have more interesting questions about a design project you're working on and you're curious to see if whether what the design you've got is patentable, please give us a call. We'd be happy to walk you through the initial elements to make sure you're thinking about novelty, non-obviousness, and the right ornamentation. Visit our website at boldpatents.com or go give us a call at 800-849-1913. Go in either direction. You can book a free 30-minute consultation with one of our patent attorneys today. I'm your host, JD Hoovener of the Bold Today Show. Go big, go bold.